All right, folks, what I want to do right now is take a look at some things that the jury is not necessarily considering, okay? Now, they've seen evidence presented to them by the prosecution and defense, but there were some significant alleged sexual incidents involving Winslow II that the jury didn't see. Prosecutors wanted to introduce some of these in the trial, but the judge ruled that they were inadmissible. Let me introduce my think tank tonight, helping us out in Vista, California. Criminal defense attorney David Shapiro is with us tonight. Also joining us is criminal defense attorney, former prosecutor Holly Waltman, former prosecutor Tanya Miller, and defense attorney Danielle Moss. Great to have you all aboard. Thank you for being here. Tonight we're going off the record. These are things that the jury does not know about, and I want to know whether you think if the jury did know about this, they would still be deliberating or not. Let's start with November of 2013, okay? A 58-year-old woman accuses Winslow of masturbating in a Target parking lot in New Jersey. He's charged with possession of synthetic marijuana. The charges in that case dropped, gone. Holly, how about if the jury knew about that? How does that change the game here?
I think it just adds to the game, right? This would be Jane Doe number 6, depending on when this happened and what time it happened. I think that he's been very, very lucky with the number of things that have been dropped, dismissed, put to the wayside, not admissible. The list goes on. And so I don't know that we would, I'm kind of surprised that we're still in deliberation, quite frankly.
Really? Okay, that's interesting. Danielle, how about the fact that a woman accuses of masturbating 2013, and then there's nothing until the more recent charges in 2018? Should we read anything into that?
I don't think so, except for the fact that if you want to bring the evidence in, one of the issues is what is the amount of time between the charges now and any of these prior bad acts, or any bad acts for that matter. So even if the charges were dropped, it doesn't matter. Did he commit an act that was so similar to the acts that he's charged with now that they should come in because they're going to shed light? Are they more prejudicial than probative? And obviously the judge found that they were highly prejudicial and didn't bring it in. And I think he's trying to keep it balanced because of the fact that we've got so many charges that are so similar, and he didn't sever the charges for the trial. So I think he wanted to keep things fair, and he didn't allow in any of this 404B evidence, basically.
So Tanya, as a former prosecutor, this doesn't come in, but what does this tell you? Part of being a prosecutor, you're law enforcement, you're to serve and protect the public, right?
Correct.
And you see an absolute pattern here with some of these things.
Right.
But what does it tell you that 2013, he gets in trouble, charges are dropped, right? Not convicted of anything.
Right.
But then he's not in trouble for another 5 years.
Yeah. So one of the things I would want to know was what is going on in his life during this period of time. It could be a couple things. One, he could have been scared straight. His brush with the law may have caused him to sort of control himself a little bit more. I don't know how long he was litigating that case, how long the courts were watching him. Presumably he had some kind of diversion program. Perhaps he was under supervision for a period of time. I don't know exactly when he got married or what was going on in his personal life, but certainly
this is towards the end of his football career, because he's in New Jersey. That's when he was presumably with the Jets.
Yeah. So who knows what's going on in his life at that particular time? I would think that the prosecution, if they were going to introduce that evidence, they would have to have some explanation for why there's that gap. It is either he's controlling himself or being controlled by something in his life, or he's doing other stuff that we just don't know about.
All right, now let's spring ahead to spring of 2018, okay? Spring of 2018. Winslow allegedly enters the women's locker room and shower area at a 24-hour Fitness and at an LA Fitness multiple times, but there are no charges related to any of this. David Shapiro, first question for you. Why isn't the jury hearing about that as a prior bad act? Seems very consistent with some of this deviant behavior that the prosecution has alleged.
Well, Vinny, I certainly agree. It's much more relevant in time, in location, and in act is what the prior allegation was about him masturbating in a vehicle in New Jersey when he played for the Jets a couple of years previously. But I think the reason why Judge Bowman kept it out, and I think, quite frankly, appropriately so, was because there wasn't as much evidence there. There wasn't as much an actual criminal act being committed. We all could probably speculate as to why he was going into a woman's bathroom or a woman's changing room, but it's not as direct as what we heard from Jane Doe 5 about the jacuzzi. it's not even direct, as much as what we saw from Jane Doe 3 as far as allegedly masturbating in her front yard.
Holly, here's the thing, and I keep coming back to this in this case. The big picture is this jury is from this community, right? So all the allegations here relate to things that happened in the community. If they heard about this as well, that he's going into 24-hour fitness and the LA Fitness and going into the women's locker rooms, I mean, doesn't it make it more difficult to utter the words not guilty?
Absolutely, 100%, Vinny, and especially with the special jury charge that the judge gave them and that California allowing evidence of one. So if they get to a guilty on Jane Doe 5 and this would have been a Jane Doe 6 or another incident, they could have used that evidence to show that this is kind of what he's into and this is what he's about. I think it's going to be a very difficult hurdle to get a not guilty on all of the counts. At best, I think the defense is hoping for some of the not guilties to come on the larger offenses, Jane Doe 1, 2, and 4.
1, 2, and 4. And when you think about what this case is really about, Tanya, this is about what the prosecution said in his closing argument, a predator, that they're trying to get a predator off the streets of San Diego.
Absolutely. And I think the judge, frankly, just did him a favor because certainly all of these incidents could have, reasonable minds could disagree about whether or not this stuff is relevant. It's not, especially the 2018 incident. He's walking into a gym, into a women's locker room. That's remarkably like what he did with Jane Doe number 5, I believe it was, when he's accosting her in the gym. So I think the judge maybe just in balancing this said, hey, okay, we get it. It's a lot. He's a predator. You've got enough with these 5 Jane Does. We're going to just kind of cut it off there. I really think it was probably just a favor to the defense.
There are some more. We're going to talk about some more stuff that's off the record that the jury's not hearing about, but also some more shocking allegations against Winslow that the jury never, ever saw. Straight ahead, folks.
I'm innocent, to the people that know me out there, know what type of person I am, my character, my NFL friends and family, and just my regular friends and family. They know who I am, and I'm an innocent guy. I'm an innocent man.
That was Kellen Winslow after one of the preliminary hearings in the case speaking, but he did not speak on the stand during the course of this trial. He has the constitutional right not to. That cannot and should not ever be used against him. Our entire system of justice crumbles if a jury holds that against him. However, in this case, it is a consent case, so it did limit some of the potential evidence the defense had for consent, because the strongest evidence of consent would have come from his mouth, right? He could have got up on the stand and said, oh yeah, I was with her, but it was consensual. We either knew each other or whatever the circumstances were, but that didn't happen, but cannot be used against him. All right, folks, we're going off the record right now with my think tank talking about some of the allegations and incidents that Kellen Winslow was involved in that are not part of this case that the jury does not know about. And let's go to June 1st of 2018. He allegedly entered the mobile home of a 71-year-old woman. She did not report it until a neighbor reported a similar incident. She said that Kellen Winslow was nice when he entered her unlocked home, and he told her it was a mistake. Wow, 71 years old, which again, consistent with many of the accusers in this case being older than Winslow is. He's in his mid-30s. So, Danielle, what do you think about a 71-year-old woman who said he was very nice, but he was in her house? He doesn't live in that neighborhood.
It's highly problematic. He's got no reason to be there other than to continue committing the acts that he's now charged with. And I think that'd be devastating for the defense team because it's an elderly woman. And it's one of the things that we hold so near and dear to us, protecting children and the elderly. So that would be highly problematic if that wound up coming into trial. I think that would have done him in.
Not just that. I mean, if he did that, he invaded the sanctity of this woman's home. I mean, it seems like he was escalating in terms of, or at least toying around with the possibility of escalating in terms of what he's willing to do to find his victims. He's not only willing to sort of prowl the streets and get homeless women or vagrants who are walking, but he's willing to actually go inside of someone's home. I think it would have been very, very devastating for the defense to have that introduced at trial. The judge did them, again, another solid in keeping that out.
David Shapiro, this case changes completely if this evidence comes in, doesn't it?
Yeah, without question, Vinny, it would. And I think what's most damning about that arrest or that incident is I think that's where, or soon thereafter, that's where they got his DNA from. From that case, from that arrest. We heard from Officer Dwyer of the Sheriff's Department talk about this encounter that he had with Winslow, and everyone sort of was being vague intentionally about how they got that DNA sample. So ironically enough, although Judge Bowman kept that out of evidence, and again, I think rightfully so, because it certainly would have been damning and extremely, extremely problematic for the defense, that is a crucial part of this case that the jury did not really know about, other than the fact that's where we got Winslow's DNA, that's where we linked him to some of these offenses, and that's what really got the ball rolling and got these 5 Jane Does before all of us.
Absolutely. And David, I just have to, it gets confusing because there's so many incidents, and this one was June 1st of 2018. There's actually one on June 7th of 2018. That is the one that involves the DNA, but it's a similar, very similar alleged circumstance. He was arrested for residential burglary when he entered an 86-year-old woman's mobile home. A neighbor told police she saw him enter and exit a few minutes later. Apparently, he entered wearing a shirt, exited not wearing a shirt. She gave them his license plate number, but that case was dismissed. I want you to take a listen to Sean Dwyer, the deputy sheriff who David Shapiro was just mentioning. Take a listen.
She asked the subject what he was doing inside the house, and he replied that he was looking for his red dog named Clifford, and then the subject left the area in the vehicle.
Did she say that she in fact asked him repeatedly what he was doing inside her neighbor's home?
Yes.
Neither Mrs. Hanson or the 86-year-old woman said that anything happened to them or anything happened to their property in the home, right?
Not to their knowledge, correct.
Right. Well, you specifically asked them, and they looked. The 86-year-old woman looked to confirm that nothing was taken, correct?
Well, not only that, but we sent evidence tech back to look for DNA evidence or something like that, and we didn't find any.
So the cases were dismissed, right? And that case was dismissed because nothing was taken from the home, nothing was stolen, no one was harmed. The only question we don't know is whether or not he ever found his red dog, Clifford.
Right.
Tanya Miller, there's an absolute pattern here that is really scary.
It is scary. And Vinnie, I would go so far as to say, if you believe what these alleged victims have testified to in this trial, and also what these other women have said about him entering into their home, there is just a matter of time before someone was going to get killed. He was essentially escalating in his behavior. He was getting bolder. He definitely has a type. He is seeking out this type. That tells me he had to have been stalking these homes for a period of time to know that these elderly women were living there. So again, this is really, really terrifying stuff.
And once again, folks, no charges. The charges were dropped. This was part of the preliminary hearing. The judge did not find enough evidence for it to go forward. Prosecutors tried to get it in, was denied, and there are no charges relative to this. Could it be a possible prior bad act? But again, the prejudicial value outweighing the probative value of that evidence. But if you look at the stuff that the jury's not hearing, it's mind-boggling how many instances, and you can understand why prosecutors were calling him a predator during their closing argument, Danielle.
It's very damning, and more so the problem is, I think if a jury hears this, they're going to say to themselves, this guy is escalating. If we don't do something about this now and we don't step in, even if they don't think the case is that strong, I think they would be willing to convict him on these weaker charges if they did hear this other evidence, because they would feel some need to step in and protect their community. This is their community.
And how about where they are now based on just the charges that they do have? Not the stuff that we're talking about here, all the off-the-record stuff, but the stuff that they're actually considering, Holly. Is that enough for this jury to perhaps have that same attitude that Danielle talks about, where, hey, we got to take this guy off the streets, or is it not quite there? And this would have put it over the top.
Oh, Vinnie, absolutely. This is where we're at. Jane Doe 1, Jane Doe 2, this is the same type of person. This is close in time. Jane Doe 4 definitely is different, but comes to the aid and trying to support the other Jane Does in this case that are a lot alike. They're elderly. A number of them don't speak English as the first language. This is a predatory act. And with these other Jane Does, we wouldn't be here still waiting for the jury.
I don't know, because I think that these two, particularly the two where he goes into their homes, are just so different. There is some you can distance yourself from Jane Doe 1 and 2 because, hey, these are homeless ladies that kind of are walking the street. Who knows what maybe they were in for a little bit of something and it just got a little out of control. But these are elderly women inside of their homes. I think those jurors would look at that and say, wow, that could be me. That could be my mother sitting inside her home, and this guy is just, prowling in with his shirt off. So I do think there is the potential that if that evidence had come in, you would see that kind of perhaps fear verdict where they just think they need to stop him and would ignore potentially the weaknesses in the prosecution's case.
And knowing all this, you know exactly why prosecutors have been so aggressive
Right.
in their prosecution here, trying to get what they believe is a predator off the streets of San Diego. Our 13th juror question for you folks, and this goes to the heart of this trial. Should the Jane Doe cases all have been tried separately, one at a time, 5 trials, not 5 Jane Does in one trial, but 5 trials, 1 Jane Doe per trial? Go to our Facebook page, let us know.
I'm Seema Iyer. Some people say I'm tough. Maybe it's because I was a prosecutor in the Bronx. I may have earned it as a lawyer representing the NYPD. Or it's because of my expertise in forensic science. Sure, some people call me tough, but on CourtTV, they call me the Queen of Crime.
The all-new CourtTV, your front row seat to justice.
All right, the Verdict Watch continues here on CourtTV. Welcome to Closing Arguments. I'm Vinnie Politan. Great to have you aboard. The jury today deliberated, and they are gone. But 6 hours and 24 minutes over the course of 2 days, and still not reaching a verdict. I'm not saying that I expected them necessarily to reach a verdict in that time, but some folks in this building did, and some folks at the courthouse may have. But again, 12 counts, 5 different accusers, and some cases that have some really interesting issues when it comes to proving a case beyond any and all reasonable doubt. So what exactly happened today? Let's go out to our CourtTV legal correspondent, Chanley Painter, live outside the courthouse in San Diego County, California, where it's sunny again, of course. All right, for folks just joining us, Chanley, give us a brief wrap-up of what we saw or heard from the jury today.
Not much from the jury. They arrived around 9 a.m. Pacific time here at the North County Courthouse. They began deliberations. They had a mid-morning break, but they had one request of the judge, one question. It happened right before lunchtime here, and they sent this exact note. They said, can we please get an aerial or satellite terrain map of Exhibit 88? Now, if you remember, this is number 88. This is the Strava map, the screenshot of Kellen Winslow's II cycling on the day of May 23rd of 2018. This is the day before the alleged indecent exposure of Jane Doe number 3. This is what shows him basically in her front yard. So they were asking for more of a terrain type or satellite type image of that location. Well, the judge responded soon after. He said, no, you have received all of the physical evidence that was received during the trial. The court cannot provide additional evidence. So what they did with that, we're not sure, or what that question even means on where they are in their deliberations. But we do know, Vinnie, that they did not take the afternoon break, which was per usual of the trial schedule, and they left a little bit early. They left around 4:15 Pacific time today. But they will be back tomorrow, 9 a.m. to continue deliberations.
Now, leaving early, was that their decision or the judge's decision?
That was their request. They made that request this afternoon around 3:30 or so. They asked, hey, can we leave a little bit early? Instead of, I guess they forgo the break to leave a little early. Maybe they were really on a roll and were getting a lot done and decided, let's just work through the break and then leave 15 minutes early.
All right, how about the lunch break? Because sometimes in some jurisdictions they order out, the food comes in and they work through lunch. Sometimes they all go to lunch together, sometimes they split apart. How did that play out today?
Good question. So lunch is on their own today. They were able to leave the courthouse. No deliberations were to take place. So when they leave the deliberation room, the judge instructed them no more discussions. You have to be all together in the same group to be able to discuss this case. He's like, if you all go to lunch together, you can talk about it at lunch. But if it's just a few of you here and there, don't talk about the case, of course, don't look at anything. And so that's what they did. They left the courthouse in like two main different groups to go to lunch and then returned around 1:30 Pacific time to resume. They seem to be pretty laid back, relaxed, don't look like they're under a lot of pressure when they're coming or going through the courthouse. So we'll see. Will we have a verdict tomorrow?
All right, now I want to get back to the first thing you reported, which was they wanted this sort of like a Google satellite image of the neighborhood of Jane Doe number 3. Now, the jury has seen Jane Doe number 3's yard in the body cam video, right? And have they seen any photos of that area?
They have. So the body cam video was pretty telling of what her front yard looks like. It's a small yard. It's walled in, like a white cement wall around the front of the yard. And they were shown pictures of the front of the home, the driveway with the cars in it. But what they were able to tell from that is that you would have to walk up the driveway towards the garage and take a left to get past the wall or the gate into the front yard where all the flowers are, where the garden is, and that's what we see on that body cam video. And so they have a pretty good idea of the arrangement of that, but maybe they wanted to see, the terrain map to see, is this exactly in her front yard, this route?
All right. Interesting stuff. We're always trying to read some tea leaves, although I've literally never read a tea leaf, and I've never met anyone who has. But maybe we'll bring in an expert to do that one day. Thank you, Chanley. So, folks, 6 hours and 24 minutes, The question I always get during deliberations, is this a long deliberation? Is this a short deliberation? Well, in order to determine whether it's short or long, you have to have some sort of baseline, some sort of a starting point of what's an average deliberation. That's why tonight I'm going to present to you Vinnie's theorem on what an average length of deliberations is. And this is based on my experience in covering trials all around the country for the last couple of decades. So this is the way it works, folks. For an average deliberation time, this is not to predict when a jury's coming back, but to give you a baseline of what an average time would be. If a trial, for every 1 day of a trial, expect about an hour of deliberations. For every week of a trial, expect about 1 day of deliberations. Okay? Pretty simple to follow, right? It's an estimation just to give you some baseline to determine whether it's a quick verdict or this jury's been out for a long time. Because we can't just say that arbitrarily. We need some place to start. So I'm starting with Vinnie's theorem. And if you look at this case, folks, right? It's about a 2-week trial. So that'd be about 2 days of deliberations. Well, yesterday was just an hour. That doesn't even count. So you had 1 day today. So a late verdict tomorrow would be about average, or an early verdict on Friday would be about average. Once we start getting late in the day on Friday and then into next week, it becomes, in my estimations, a long deliberation. But that's just me. I've got my think tank with me, all very experienced attorneys, all free to agree or disagree. David Shapiro, criminal defense attorney out in San Diego. And here we've got with us Danielle Moss, criminal defense attorney, Tanya Miller, former prosecutor, and Holly Waltman, criminal defense attorney, who's also a former prosecutor. David, I'll start with you because you're on the ground out there in San Diego. What's an average length of deliberation? Do you agree with Vinnie's theorem?
I do agree with Vinnie's theorem. Usually I agree, a couple days, 4 or 5 days usually leads to about a day of deliberations. But what I can tell you from my own experience, Vinnie, is that I've tried cases that lasted 2 days and the jury was out 4 days. So that would obviously contradict your theorem. I've tried cases that have gone, 2 weeks and the jury was out, an hour and a half, 2 hours. But generally speaking, I think you're pretty dead on. And I think that's what we're expecting here, at least myself and the criminal defense attorneys in the San Diego community I've talked about. We're thinking probably late Thursday, Friday, we'll at least hear something, whether they're deadlocked, whether they have verdicts on some, or whether they have verdicts on all.
All right, Danielle, what do you think about the length of deliberations, where we are now, and when either side should start saying, wow, this is taking some time?
I think it's a crapshoot. I've had cases, I've had a rape trial, came back in 45 minutes, not guilty. I've had a rape trial, they were out for 5 days, guilty. It's hard to say. We like to believe that if they come back quickly, it's a guilty. A lot of people believe that. If the jury comes back quickly, it's a guilty. But that's not always the case. You know, a jury is this beast all unto itself. You don't know what they're doing. You don't know what they're talking about. You know, just like this map they wanted to look at. Why do they want to look at this map? We could sit here and speculate all day long.
We will. That's what we do. Hey, Tanya, where are we right now in this trial?
Okay,
are we still early?
I think we are right about where we should be. I would start to worry if I was the prosecutor if we went beyond Friday. Because typically, if you've had a trial that's been about a week, the jury gets it, they're going to want to leave before the weekend. If they get any amount of time to deliberate before the weekend and they're going to reach a verdict, they're going to do it before the weekend because they don't want to come back. So I think if they go beyond Friday, there may be a problem back there.
Tanya, you're just talking about Vinnie's theorem 2.0, which is the Friday factor.
The Friday factor.
The Friday factor can speed things up a lot. I would say a good 60 to 75% of the verdicts that I've covered through the years on CourtTV have been on Fridays. And sometimes they start on Monday, sometimes they start on Wednesday. Something about Friday. Holly, where do you think we are right now?
I'm going to take it a step further and say we're going to get a verdict before lunch Friday because they're going to want to get out of there. They've been tirelessly working on this case, and through voir dire, I mean, the trial itself was almost 2 weeks, but they were there for a lot longer. And Chanley's been reporting, and a lot of people over in California have been reporting that they've been taking diligent notes and tirelessly just going through this stuff. I think we get a verdict before lunch Friday, and they take the weekend to decompress and reset.
All right, well, let's talk about the question, the only question that they had, the note that they sent out about this Strava app. Again, it's based upon Exhibit 88, which we have a copy of. And Exhibit 88 was from this Strava app, which tracks your motions, where you're going. And according to prosecutors, Winslow wears it when he goes cycling. So the red squiggly line you see is the route that prosecutors say that Winslow took the day before the alleged exposure to Jane Doe number 3. So the squiggly part there on the bottom is Jane Doe number 3's front yard. And what prosecutors are saying is that he was staking out her yard and was there the day before he exposed himself. And today the jury asked for a topographical satellite type map of that area, maybe something like you would get on Google. If you go to Google Earth, or you go to Google satellite images and you can kind of zoom in and see the trees, the houses, and everything else there. David Shapiro, your thoughts about this request. Is it better for one side or the other, first of all?
Well, first off, Vinny, I think it's better for the defense because if I'm representing Winslow, I'm thinking, okay, well, the jury's not rubber stamping Jane Doe 3's accusations here. They're looking into it. They're looking into whether or not he was just driving by or whether or not there's some allegations here that he actually rode up onto the driveway. So, you know, the fact they're thinking about it is a good thing. How long they thought about it before making that note, how long they thought about it after receiving that note from Judge Bowman, you know, we'll know in due time. But I would be encouraged if I am representing Winslow as a defense attorney that at least they're thinking about it. And we're in, you know, full day of deliberations here. And it was the first note they asked. Now, on the flip side, I'm concerned because that Strava app was damning evidence as it relates to Jane Doe 3.
Yeah, and I'm watching everyone here is going, yes, yes, yes. So everyone agrees, no one disagrees here, that this is better for the defense generally?
I think it is better for the defense generally. I mean, anytime the jury is digging down into detail, especially when you've got 5 victims, if you're the prosecutor, you're thinking, hey, the strength in this case is that we've got all of these victims, we've got all of their stories. There's no need to get into the weeds. Look at the big picture of this thing. If you're the defense, you want them to be parsing out each and every one of these Jane Doe's story. And I think the fact that they're asking for that could mean that that's exactly what they're doing back there. They're trying to figure out what exactly was his vantage point when he stopped, according to this app. Could he have seen what was going on? Was there something obstructing his view? Could the victim could her story somehow be contradicted if we have a good look at the terrain? So I think overall, it is not a question. If I'm the prosecutor, then I'm particularly happy.
I want the record to be clear, though. You said getting into the weeds. Jane Doe number 3
had no weeds.
There was no evidence of any weeds, just flowers.
Just flowers, my bad.
She was trying to take care of her flowers, and that became the subject matter of the original conversation, according to Jane Doe number 3. The first time he came over, he was talking about her flowers, and then she said on that body cam, he didn't want my flowers, and it was a powerful moment, but again, the jury wanted to see that map today. Our 13th juror question for you folks. Should the Jane Doe cases all have been tried separately? Should we have had 5 trials instead of just 1? Let me know. Go to our Facebook page, vote yes or no.
Your duty as a juror is to decide the facts that have been proven. You have a privilege and you have a responsibility as members of the community to find this defendant guilty, because that's what's been proven. This was vile, perverted, despicable sexual domination. That's what he does. The man who raped her told her, "I'm gonna when they were outside." What do we have happen with Jane Doe 2? He actually penetrates her ankle. He chose to rape a woman he met on the streets and a woman he knew to be homeless because he knew that he would be able to deny it. This man took what he wanted from them and threw them aside like a piece of trash, because that's what he thought that they were. Their faces may not be shown, but their voices are heard. And do not allow his status or his name to take away from that.
Powerful closing argument from the prosecutor, Dan Owens. And today, folks, the jury deliberated, did not reach a verdict. They were out for 6 hours and 24 minutes total. They did about an hour yesterday, and a full day today with no verdict. So we're going to take some time right now to walk through some of the allegations and some of the accusers in this case. Remember, 5 Jane Does here. 3 of them are alleging forcible rape. So we're going to take a look at each one of their cases. Let's begin with Jane Doe number 1.
Jane Doe number 1 is a 54-year-old hitchhiker who says Winslow, after picking her up in a black Jeep, drove behind a shopping center, forced her to perform oral sex, and then raped her. She reported the incident 4 days later. Winslow's DNA was detected in a sample taken from her pants, but Jane Doe 1 was unable to identify Winslow in court during the preliminary hearing, pointing to his attorney instead.
On the day that this happened, did you want to have sex with the man who had picked you up in his car?
No.
Did you want to be taken to the back of that shopping center against your will?
No.
Did you want to perform oral sex on him?
No.
Would you have done any of those things if he hadn't threatened to kill you?
No.
You came to court, you testified before the lawyers and the judge, right? Remember that?
Yes.
Okay. And you remember you pointed out this man
Right.
as being the individual who raped you. Remember that?
Yes.
Okay. This man I'm standing in front of.
Yes.
For the record, this is Mr. Watkins.
The record will so reflect.
Is that still the person who raped you?
No, it's the one next to you.
We know that it was him. We know that the sex act occurred. We know where it occurred. So why is she being cross-examined at length about whether it was a Jeep or if she saw a Jeep emblem? We have surveillance video from his own surveillance system that shows him leaving in his black H2 Hummer. Ladies and gentlemen, that's where it happened. Where else could it have happened?
And I'm sorry. You know, they're gonna say we take our victims as we find them. Well, she's not. She's not a victim because clearly she's not frozen. She climbed a fence. She put her hands into a chain link fence and climbed over a fence. Took the care to throw her valuables over the fence and did it again. It's not a victim.
Now, another important part of the story of Jane Doe number 1 in the investigation is she reports this to police but can't identify her attacker. She doesn't know who he is. So the case sort of goes to the back burner until Jane Doe number 2, and there's some DNA that is found, and then they're able to match the whole thing together. Now, the charges involving Jane Doe number 1. Count 1, kidnapping for a specific felony. Count 2, forcible rape. Count 3, forcible oral copulation. Let me bring back in my think tank on Jane Doe number 1. And this is something I've been talking about a lot today. And I'll start with you, David Shapiro. You know, the jury's back there deliberating, and these women came in and told their stories. Jane Doe number 1 told her story. So to find him not guilty, one of the things they may be considering is she's lying. But I have a question, and is there a reasonable explanation as to why she would lie about this? Why she would come into court and lie about being raped?
Well, Vinny, I think there's a couple of reasons. I mean, one, she could be ashamed for having consensual sex with another individual that she just met. She could be ashamed in having to explain why she had blood on her pants walking downtown Encinitas. But I think the real issue is, as far as the jury goes, is they could just believe that she was mistaken, not necessarily that she was outwardly lying. I mean, they could believe it could be a combination of two. I mean, she's a proven liar about things far less significant than whether or not Kellen Winslow forcefully raped her and kidnapped her. So I think it could be a hybrid of the two, where the jury may not be convinced beyond a reasonable doubt that she's telling the truth. Doesn't necessarily mean that she's a liar. They can just believe that she's mistaken.
She said she was,
similarly as it relates to some other Jane Does.
So, and let me just clarify what you mean by mistake. Mistaken identification because it's a DNA case, or mistaken that he didn't really threaten to kill me? I really didn't say, ow. I really didn't say, stop. I really consented even though I didn't? Is that what the mistake would be?
Well, no, not mistaken identity. I mean, that's clear based on the DNA and based on, although the jury didn't hear it, I mean, it was certainly mentioned in opening statement that Winslow consented to having sex with her. But just mistake in general, and I think that's where the defense was going with the questions about, well, you mistakenly identified Brian Watkins instead of Kellen Winslow. It just cast doubt and cast some credibility concerns on anything else she said, most notably with consent, most notably if she's this erratic in her behavior and her recollection of things. You know, maybe in her head she believed she was forcefully raped, but maybe in that moment she wasn't. You know, it could be a combination of things that can get them to a not guilty as it relates to Jane Doe 1.
You know, there's another question, and I want to put this to the folks here. The DNA puts them together for sure, right? So there's some level of sexual contact and conduct between these two.
Yes.
Could the jury be trying to ask themselves or trying to answer the question, why is Kellen Winslow II engaging in sexual conduct with this woman?
Yes. I think that's one of the things that, you know, is a problem for Kellen Winslow. I mean, look at this guy. He is this, you know, famous football player. He's got this beautiful wife. He's got this picture-perfect life.
Tens of millions of dollars.
He's a millionaire. He's he's a decent-looking guy. It seems to me he could go to any club and get some woman who'd probably go on a date with him. Yet and still he is having some kind of sexual contact with a woman like Jane Doe number 1. It doesn't make a lot of sense. It doesn't seem like this would be the type of thing he would do in a consensual way, especially if you look at the pattern of behavior.
Is there an explanation for this conduct that is non-criminal?
Well, I mean, it simply could have been just money for sex. You know, something simple like that. And I do think that she does have a faulty memory. She's had problems when it came to the menstruation, the issue of whether or not, in fact, the blood was due to forcible rape compared to whether or not she was menstruating. She went back and forth at the preliminary hearing on that.
Bunch of times.
You know, that was really problematic, I think, for the state. But also, it could have been that maybe initially she wanted to do this, and then after the fact, she was humiliated by it.
But why go to the police? That's what I'm trying to figure out. Why? Like, if you're humiliated by it, you don't even know who the guy is, so you just report a rape by someone who you don't even know who they are?
It doesn't make sense.
Does that make sense to anyone?
Not to me. Not to me.
I think that one of the things that's going to be really interesting to see is the jury coming back on that first count, the kidnapping count,
yeah.
Because Mark Carlos in his closing nailed that, right? She climbed over a fence. She's not frozen in fear. And one thing that I think the state could have done a better job at is explaining that even if it was consensual at some point, which they would argue there was no evidence of, at any point she can withdraw that consent. And so perhaps the first count, the kidnapping one, there's maybe not proof beyond a reasonable doubt, but certainly on the second and third, what is the rational, reasonable explanation for her coming in and saying all of those very graphic details about ouch, quit, stop, please? I don't know that they get past the other two counts.
Well, I think the state did not do a good enough job, in my opinion, of explaining to the jury how trauma victims react differently to trauma.
Exactly. We talked a lot about that beforehand. It didn't happen in this case. Folks, 5 Jane Does, our 13th juror question. Should the Jane Doe cases all have been tried separately, one at a time? Different jury for each one. Let me know.
CourtTV has returned to television.
Bringing you the cases that change our world.
My client is on trial here for his life.
With live gavel-to-gavel trial coverage from across America. You'll be there for every compelling moment.
Did you lie to the detective?
Can you keep my life straight?
As history unfolds.
Guilty of first-degree murder.
Emotions rise, and justice is served.
The all-new Court TV, your front row seat to justice.
The only thing that matters, the only thing that matters, are you people right here. That he said there were 5 accusers. 21 times he said, 5 accusers, 5 accusers, 5 accusers, 5 accusers, 5 accusers. You should look at the credibility of the witnesses, and that's what this case is. Credibility of witnesses. She's not a victim, because clearly she's not frozen. She climbed a fence. Once again, all of this is consistent. Every single piece of evidence here now is consistent with a consensual encounter. If she can scream, bring it on, she can't scream help. The questioning about her menstruating is important for that reason, because it shows that she is willing to play hard and loose with the facts, so to speak. She will lie if she has to. There is no blood inside of the Hummer. 0. They want you to speculate. They are throwing things up for you to attach a guilty persona to Mr. Winslow. I am sure, I'm positive, that if you apply the law the right way, listen to what I've said, that you can come to the only reasonable conclusion, and that is that Kellen Winslow is not guilty of the charges that have been levied against him. There clearly is insufficient evidence to convince anybody beyond a reasonable doubt.
Defense attorney Mark Carlos pointing out and doing really a good job of pointing out all the problems that prosecutors have with each of these individual cases. But the biggest problem for the defense is that there are cases, there are 5 of them lodged against Kellen Winslow in this trial. So we've been breaking them down one by one and really focusing on the 3 forcible rape accusers in this case. Right now, let's turn to Jane Doe number 2.
A 59-year-old self-described homeless woman, Jane Doe 2, says Kellen Winslow offered to take her to coffee on Mother's Day 2018. After getting into his vehicle, she says Winslow drove to a remote location where he raped and sodomized her while threatening to kill her. There's no DNA evidence, but Jane Doe 2 went to police the next morning and has no problem identifying Kellen Winslow.
He held me, grabbed my arms, and I don't know what else he said, but he says we're gonna have sex. And I said, please don't do this. And I said it about 4 times, and something like, it's a done deal.
At the same time, you said that you met Mr. Winslow probably about 6 months prior. This happened, right?
I really don't want to look at him, sir.
You said about 6
I
months.
don't appreciate it.
Appreciate what? What is it you don't appreciate?
That I have to look at my rapist. I think he should be further over.
Jane Doe number 2. Soft-spoken, timid, shuddering, afraid. Afraid of being in the same room as her rapist. Afraid to even look at him. Is that all an act? Is that a lie? Well, certainly not. Make no mistake, ladies and gentlemen, she had something taken from her by this man in court, and do not allow his status or his name to take away from that. Make no mistake, Jane Doe number 2 had something taken from her that cannot be given back, that cannot be made whole. And you saw that on display before you.
After she reported this strangulation, this choking by this man, she looked in the mirror and saw that she had no marks, nothing, 0. You didn't hear anything from any evidence tech about DNA found in his fingernails, her fingernails, from scratching she did of this individual, about any bruising that was on her hands. Remember she said that this guy grabbed her by the hands and pushed her down? No bruising on the hands, no bruising on the fingers, no bruising on the legs, no bruising on the back, no bruising on any single part of her body. Nothing, zero, no evidence whatsoever. So, ladies and gentlemen, let's be clear about this. The only evidence of any assault comes from her, and that's it. Don't be fooled to say there's some type of circumstantial evidence that they presented, which is credible, because there's nothing.
I have to point this out every time I hear that argument. This is the first time I've ever heard a criminal defense attorney jumping up and screaming that you can't convict, there's no circumstantial evidence here. It's always the opposite. It's like, there's no direct evidence. This is merely a circumstantial case, ladies and gentlemen. So if on the one hand it's merely circumstantial, why do you need the circumstantial in order to find him guilty? Because they have the direct evidence. The direct evidence came from Jane Doe number 2. I'm just pointing out the irony, but it was an effective argument made by Mark Carlos inside the courtroom for this jury, because they don't listen to all the arguments that are made in all the trials that I tried and that I've covered through the years, where defense attorneys always say, this is just a circumstantial case. You can't convict on circumstantial evidence. Now he's saying you can't convict without circumstantial evidence. How does that work? All right, let me bring back in my folks. Oh, by the way, let me show you the charges related to Jane Doe number 2. It's count 4, which is forcible rape. Count 5, sodomy by use of force. Now, the circumstantial evidence that he was looking for was maybe some of those marks that may have been left on the neck. The photos of Jane Doe number 2's neck was actually entered into evidence. We've got a picture of those for you that we can show you what it shows or does not show in this case. So let me begin here. Start with the photo.
I don't see anything on there, but just because we don't see anything doesn't mean it didn't happen, right? Her testimony alone, like you were pointing out, is direct evidence of this happening, and that, if believed by the fact finders, is sufficient. 4 and 5, check and check, and that's why I think now we're hearing about questions for Jane Doe 3. I think they're done with this part of the deliberations.
Has anyone here ever argued this is a case, there's only direct evidence here, folks? There's no circumstantial evidence, you cannot convict?
Never. I think he wanted to say corroborating evidence, something that's just going to back up her stark allegation, because this is a problematic situation that they're in. There is no visible evidence, and it's something I argue all the time. Where are the injuries if this in fact happened? How is it that someone's been sodomized and there's no lacerations, there's no abrasions, there's absolutely no forensic evidence to back what I think is an incredibly violent act that would have to cause some type of injury to the genital and anal area?
Well, I mean, look, I think this is the argument that you make as a defense lawyer to a jury that doesn't know any better. And I think perhaps the prosecution should have done a better job of explaining to the jury why the fact that there is an absence of physical manifestations does not mean that there was not an attack, that there was not a rape. There is a very small percentage. In reality, prosecutors know this, defense attorneys know this if they try these cases, a very small percentage of those cases where you're going to see any physical trauma to the vagina, to the anus, when there is a sexual assault. I don't know that the jury knew that, and I think he capitalized on that.
The one expert who testified said in about 50% of the cases they don't see any evidence like that. David Shapiro, what do you think? The fact that there are no choke marks on the neck, is that enough to raise a reasonable doubt about this whole story?
Well, I think that's part of where Mark Carlos was going at yesterday, Vinny, talking about the fact that could be 2 or more reasonable interpretations of this evidence. Well, one could be what their experts and what the SART nurse talked about, which is only 50% of the time or so you expect to see these types of injuries. Could that be consistent with Winslow raping her forcefully? Absolutely. Could it also be consistent with her making it up or over-exaggerating whether or not there was consent or not? Absolutely. And I think the reason why he was focusing, he being Mark Carlos, was focusing so much on circumstantial evidence and talking about, well, you need something more with direct evidence, because they didn't provide any direct evidence by way of the testimony of their client for a number of reasons, I'm sure. So what they do is they hone in on the 2 or more reasonable interpretations of circumstantial evidence, because all the jury would need to do as it relates to circumstantial evidence would say, hey, I think that's reasonable. I don't necessarily agree with it. I think it's reasonable. And if that's the case, if they acknowledge it as reasonable, the law here in California says they must acquit him, whether they believe he's factually innocent or not.
All right, I want to get back to my question of the night, which is why. All right, so if the jury's deliberating and they're deciding whether or not to believe Jane Doe number 2, maybe they've got to discuss the question of, does she have any motive to lie? Why would she lie about this?
Of course, and I think as a prosecutor, that was always what I led with. I mean, if there is no clear motive for her to lie, what the defense needs to explain to you. If they're going to just accuse her of being a liar, they need to tell you why she is lying. You don't make up a lie like this. I think that's what the prosecutor tried to say, and I think all prosecutors will say that. I frankly don't see the evidence of motive to lie. I think the detail that this Jane Doe number 2 gave was compelling. I didn't get to see her face, but hearing her story was compelling. She sounded believable to me, and we cannot forget, she is not alone. She has no relationship to Jane Doe number 1, yet her story is remarkably consistent, not to mention all the other sexual stuff this jury heard. So I think that, you know, I just think that to say that the defense to this is that she's just coming in here and making it up is really a weak defense. It's all they got, but I think it's weak.
Is there a plausible explanation as to why she would lie?
I can't find one, if there is, other than potentially saying down the line, now, I'm going to continue at this because I started on this, and I don't want to be charged myself for giving false information or for lying to the police, and also potentially the motive could be later on money to go after him civilly.
Yeah, no civil suits here though. Yet.
Not yet.
Having testified as a professional witness in trials and in hearings, it's nerve-wracking. You don't want to be up there, and you certainly don't want to be up there making this up or fabricating a story. To me, like you said, Tanya, I didn't see her face, but I heard her voice, and the fact that she wouldn't look over there and didn't want to point him out, to me, I don't see a clear reason why she was doing this if it was made up.
Yeah, and they did have some level of a prior relationship, which wasn't 100% clear as to the nature of it. We didn't get any clarity from the defense, not that they have to provide that, but they didn't provide any. And we're kind of left with this really vague interpretation of their relationship, which might lead to an explanation as to why she would accuse the man she knew as Kevin, but it didn't happen. It's really one of those unanswered questions in this case. I have another unanswered question. It's our poll, our 13th juror question. Should the Jane Doe cases all have been tried separately? I want to know what you have to think about this one. Go to our Facebook page. You can vote. Also, leave a comment. Our handle is CourtTV. Another day, no verdict from the jury. They deliberated for 6 hours and 24 minutes out there in San Diego. About an hour yesterday, but a full day today. They just had one question. They wanted one thing that the judge could not provide to them. Other than that, they were busy in their jury room deliberating. They took their lunch break, everything else. And it will continue, folks. It will continue. So we're taking the time right now to take a look at the different Jane Does, because each one told a different story on the witness stand, different evidence, different issues involved in the cases. And we're focusing tonight on the rape accusers. So now we're going to talk about Jane Doe number 4.
Jane Doe 4 was 17 in 2003 when she says a then 19-year-old Winslow assaulted her while she was passed out from drinking. She told police she knew it was Winslow because he was a well-known college football player and she had a consensual sexual encounter the first time they met. Jane Doe 4 says when she woke up during the alleged assault, she told Winslow no and told him to stop, which he did not do. She came forward after finding out Winslow had been arrested for sexual assault.
Why would anybody believe me?
Other than talking to Nicole about what had happened, did you tell anybody else here in San Diego before moving to Hawaii?
No.
Why not?
Because I think nobody would have believed me. They would have, you know, in your mind, you're kind of like, did you allow yourself to go in that situation?
Is that how you felt?
Yes.
Well, you say no, right?
I say stop.
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 Okay. And that's what you recall, saying stop.
Yes.
And then you push against him, the way you described it, you pushed against him with the palms of your hand backwards on his thighs.
Yes.
So with both hands?
With both of my hands.
So did you then lie face down?
Yes.
Do that?
So my face is now against the bed, and my hands pushing against his thighs.
Okay.
Who's the person who's going to remember the details? The rape victim. Who's going to know what actually happened on the 2 interactions she had with this man? Not her friend who's being asked about it 16 years later. Her. Was she lying to you based on some motive? Based on some incentive to try to really get this guy that she hadn't had any interaction with for the last 15 years? That's unreasonable, and you can reject that argument.
She decides she's going to call the police. I'm going to call them. I'm going to call law enforcement, and I am going to relate what happened to me. Right? Now, this is really, really, really important because the prosecution doesn't even want to address it. They didn't do it in their direct, and I challenge them to say something on their rebuttal about this because they know what it means. Because Jane Doe 4 had the opportunity to think about what she was going to say. She had 15 years to think about what she was going to say.
And some facts about Jane Doe number 4, when she calls in, when she does, is when it's all in the news about the other Jane Does coming forward. And Kellen Winslow is in the news, she sees it, and then decides to make the call. Now, the testimony in the trial is that she made the call not necessarily wanting to pursue the case, but being there to support the other Jane Does. Now, the counts that are involved with Jane Doe number 4, count 7, which is forcible rape, and count 8, rape of an unconscious person. Another part of the case of Jane Doe number 4, which a lot of people were talking about, was a photograph that was part of the evidence. And this is a photograph. We blurred out Jane Doe number 4. That's her and Kellen Winslow the day of the alleged rape. That's it, in the car at that convenience station 16 years ago. This is pre-digital photograph. So this is a photograph that had to be developed and physically kept, not like on your Facebook page or somewhere else like we would today, but this is an actual photograph back from 2003. So, David Shapiro, I want to, again, go to my question of the night, which is why, if this jury is going to disbelieve Jane Doe number 4, they have to believe that she is not telling the truth on the witness stand because she was very specific about what she remembers and does not remember and what was happening and what she said. Does she have any plausible motive to lie about that?
Well, Vinny, I think that she might. I mean, I don't know if it's been developed as well enough as it probably could have or should have at the trial, but this was a woman who certainly had consensual sexual intercourse with Mr. Winslow at least 2 weeks beforehand. The reason why she would lie at this time is interesting, was not really explained, was not really developed, as I alluded to, but it is concerning as to her ability to lie arguably at the trial or have lied when she first reported the crime or the alleged crime to the San Diego Sheriff's Department. The differences between what she told the sergeant or the head of sex crimes in the Sheriff's Department versus what she later told the district attorney investigator compared to what she told the jury. So there's certainly inconsistencies there. The issue is at what point, if any, was she lying? At what point, if any, was she mistaken? But I certainly think the defense developed that well as it relates to the closing argument as to what she said to the first person from law enforcement she gave the complaint to.
And how about this photograph? How does that all play, Holly? You know, it's a photograph from 2003 that she kept. She explained that it was kept as a reminder, you know, that things can go really bad. Things can be dangerous situations, even when you think you're not in danger.
That was a chilling part of her testimony for me, Vinny. And at the onset of this trial, I really thought that the defense was going to have the easiest time explaining this, this count in this Jane Doe because of the amount of time that had gone by. But truth be told, if she was doing this for a financial gain, she surely wouldn't have done it after she's seen him in trouble with other accusers. After
maybe do it when he's got his $40 million
and
his money.
That's what I was about to say. Before he retained these defense, this dream defense team, This is not when you come forward with the financial gain angle of this. It wasn't developed because it really wasn't there. And I think that Mark Carlos, had he tried to go down that route, would have lost a lot of credibility with the jurors. And everything else that he really wanted to stick to them and for them to remember would have had less teeth.
All right, let's check back in with Chanley Painter with a look ahead to tomorrow as deliberations continue.
Verdict watch continues tomorrow here at the North County Courthouse. 9 a.m. Vinnie, the jury will gather again in the deliberation room to parse out all 12 counts against Kellen Winslow II. Today, they seem pretty upbeat and relaxed as they took a mid-morning break and an hour-and-a-half lunch break. But right before lunch, they had a question for the judge concerning exhibit number 88, the Strava screenshot showing Kellen Winslow II in the front yard of Jane Doe number 3 the day before the alleged incident, indecent exposure. Will they have more questions tomorrow? We'll find out in the morning, 9 a.m., like I said, Pacific time. Hey, we might even have a verdict in this case tomorrow. You won't know unless you watch us all day live.